back. Thank you so much for joining us on Let's Talk Seniors Memory Care Issues, Alzheimer's, Dementia, and Parkinson's. Here for another edition. We have an exciting guest today. I'm Deirdre Vervo, and many of you may know me from being the author of Home to Home, the step-by-step senior housing guide. If you'd like a free copy, give me a shout out, email me, text me, whatever you'd like. I'm happy to send it. This book tells you all about the different kinds of housing for seniors, whether it's to stay at home, do reverse mortgage on your own home, go into assisted living, memory care, nursing home, independent living. It gives you all the options because it's not just home or nursing home anymore. There's lots of options in between. So it explains it all. Some of you might know me as the person that runs Just Like Home's Dogwood Home, the 6-person home we have in Shelton for seniors with memory care issues and that need assisted living needs. If you're interested in learning more about this, also give me a shout out. Today we have a special guest, a friend of mine who I've known for maybe 40 years. And his name is Ed Kelleher, attorney Ed Kelleher. He is going to tell us the importance of wills, how to avoid probate, what you need, just even a healthcare proxy, like what are the basics you need for your senior. If you're taking care of a senior, if your parents are, like, what do they need? So many times I come across people that do not have a proper will in place, do not have a proper trust in place, and their family is stuck going through long probate. They're stuck paying high taxes on their home. They can't sell it. So what do you need? What are the basics without breaking the bank? Without further ado, we're going to have attorney Ed Kelleher join us. Hi, Ed. How are you?
Hey. Hi, Deirdre. Great to see you again.
Yes,
Glad to be on with you.
As always, Ed, you're the best. Why don't you tell us a little bit about your legal background and how you got into specializing with not just real estate, but wills and trusts and estates and working with seniors and even people not so senior that want to get their estate planning in order.
Sure. Deirdre, I've been practicing law for 35 years now, and all of it in Connecticut. And started out doing primarily litigation work, but I always enjoyed the estate planning and dealing with wills and trusts and things like that. So ultimately eventually got tired of a steady diet of litigation and kind of hung out my shingle to do represent people individually, help them with setting up small LLCs, doing wills, trusts, kind of the things that, people, individuals and families need. And I really enjoy it. It's basically people have a problem they need to solve. And in connection with the, estate planning side, they have money, some have more, some have less, but everybody needs to do some kind of estate planning. And so it's kind of a problem that they need to solve. How am I going to get, first of all, manage during my life when I might have become incapacitated, unable to handle my own affairs, or ultimately when I pass away and I need to, and I want to make provisions for my spouse, my children, sometimes even a pet, so that the process is easy for them. And that you've exercised control over not only your life, but also over who gets what when you die and who gets to manage your property.
I think it is so important to plan this because people don't realize that it might cost a little money up front, but what you're going to save on the back end is not just time, aggravation, but so much money. And I don't know if I shared this with you, but my mother-in-law, my ex-mother-in-law who passed last year, never had a dime to her name, but she did have a house that she was able to sell about 10, 12 years ago for $440,000. And they put that into a trust just in case she was going to need to go into a nursing home. And you could talk more about this, but So she put it in a trust so that if there's a 5-year look back with the trust, but if she were to live for 5 years and not go into a nursing home year 6, she could go into a nursing home and that trust would not be touched, correct?
That's right. As long as there's proper language in the trust to protect the money from the so that it's not counted as an asset. Yes.
Correct. So what happened in this case is they went ahead and did the trust, but told the attorney they were going to use the trust for her care. So in the trust, the first paragraph says this trust is to be used for her care. Thus, when she went into a nursing home for 5 or 6 years, she had to use all that money. So there was zero protection. So what should they have done?
Well, there's a trust that I can draft, which is called a Medicaid Asset Protection Trust. And there is the 5-year look back period. And what that means is that you become disqualified from Medicaid eligibility for a period of time. And it's calculated, Medicaid looks at 5 years back. Have you made any gifts or have you given anything away for less than fair market value in the last 5 years? If you have, then there's a formula that they use to calculate, all right, well, how long are you ineligible for Medicaid? And really, to kind of put it most simply, if you gave away $150,000, okay, and then the cost of the Medicaid and nursing home in a month was just, for example, $10,000, then you are, and this is a very simplistic example, but you would then be ineligible for 15 months. So it's 150,000 divided by $10,000 a month.
So basically, you would be eligible if 5 years passed.
If 5 years passed before you applied for Medicaid, they wouldn't even necessarily know. You wouldn't even have to report that gift.
If you put the right language in.
Right. If you haven't put the right language in the trust, the trust has to have language in it that says that the trustee can withhold money, doesn't have to give you any money. The idea is that if you are in a position to demand that the trustee give you money, then Medicaid stands in your shoes, and they're in a position to demand that the trustee give you money. And so the trust has to be drafted to protect against that.
Yeah, so I believe it's very important to go to an expert lawyer like you are, because they went to a lawyer, and I'm sure they told the lawyer, we are going to use this money for my mom as she gets older. So that's what he put in the trust. But he should have said, we're going to put in the trust not to be used for her care, but you can do it whatever you want. You could use it for her care, but if you say we're going to use it for her care, then you don't get Medicaid.
Well, that's basically the trade-off, yeah.
Right, but if you say we're not using it for her care, you can use it for her care. It's up to you, right?
Right.
Or you can get on Medicaid. So they were quite dismayed to learn. They tried to get Medicaid in New York, tried to get Medicaid in Connecticut. And because that was one sentence in the first paragraph of the trust, they lost out. So that was disheartening. So that's just an example of, if you go to an attorney that does not know what they're doing and you think that you have it all ironed out, you may not. So it's very important to go with somebody that's been doing it as a specialty, as you have been for years, because you will do it correctly.
Yeah, it's not the kind of thing that you would take to the person who handled your house sale or the refinance, or your criminal lawyer. If you know a criminal lawyer, to handle a traffic ticket or something, they're really not qualified, typically to do that kind of thing, because there are a lot of considerations, and it really can be a pretty complex analysis as to what you have to do with your assets, where you move them, who you give them to, the kind of vehicles that you put them in order to protect them. So yeah, it's a complex analysis and requires right.
So what do you have to do to save yourself from probate?
Well, to save yourself from probate, okay, so probate is the process where, after someone passes away, the survivors need to change the title to the property that the person owns. And it involves a couple of things. One, who is going to be involved and who's going to manage the process. That's typically the executor. And then the other part is who gets what, and that is handled by the will. In order to avoid probate altogether, really the best way to do it is to put all of your property into a revocable living trust, because probate only controls property which is in your name alone. Okay, so if you have a house in your name, that's probate property. You have a bank account that's just in your name and you don't own with someone else, or it doesn't have transfer on death provisions or pay on death provisions or a joint owner. If it doesn't have those things, then it's owned in your name, and that's probate property.
So what if your parent puts you on their bank account, puts you on their title? Does that eliminate probate?
That would eliminate, that becomes a joint asset of theirs, and so that would pass outside probate. It's not. That's not a good idea for a lot of reasons.
How come?
Well, for instance, you've got everybody's situation is different, but the parent might put the child on the house thinking, all right, well, this is great, we'll avoid probate. Well, the child might have creditors that the parent doesn't know about, and the child may just be frankly too embarrassed to tell their parent that they've got creditors. They've got maybe a big tax bill that they haven't paid. If they've got a big tax bill, then the house that mom just gave them half of is going to be subject to a tax lien, and it could be sold at mom's interest as well. So,
mom's still living there.
The house would be the child's interest would be subject to the lien, not the mother's. But a foreclosure could be started. I mean, that's a worst case scenario. But the problem is that it is subject to those creditors. That's really kind of the big issue. It's really more of an issue with a bank account, where a bank account can be garnished quickly and easily. People will put a child on a bank account with them really kind of for ease of administration. And then if the child has creditors, his creditors can garnish that account really very easily. And then you've got to fight to get that money back. And most of the time you won't get it.
So that's not the wisest idea, because you could put your child on an account, is what you're saying, or on your house. And you could, 10 years can go by, everything's going smoothly, and you have no idea that the kid might have some sort of debt. And then they're leaving the house, and you might want to sell the house and move on because you're in perfectly good health. And then, wow, you don't get all your money because they're on it.
Right.
Or that could be repossessed or foreclosed upon. That is crazy.
That is crazy, yeah. So with a revocable living trust, you can accomplish really what you want to do. The purpose of the trust, a big part of it is to avoid probate, because it's not your property in your name alone. So it's not considered probate property. It is, you have the right to, with a revocable trust, you have the right to take the house out of that trust to put more money in the trust. You can do with it whatever you want during your life. You are the trustee typically of your own trust. But one of the nice things about a revocable living trust is that it covers you in the event you become incapacitated. You have named that child, for instance, this child you trust and have full faith in, to be your successor trustee. So if you become incapacitated, you can't handle your affairs like you ordinarily would, your child can step into your shoes as trustee. Now, they don't gain any ownership rights to any of that property, just by virtue of being trustee. They're managing it for you, and they'll continue to manage it for you for as long as they're trustee, for as long as you're alive.
So do they have to go to court? And so let's say you're the trustee of your parents' estate, and they put in a revocable living trust, and then they're in a nursing home. How do you get control of their assets?
If you are the trustee, your parents have created a trust. Just to make sure I understand the question. Your parents have created a trust, and they put all their assets in the trust, and they're no longer serving as trustees because of dementia or some other reason. Is that the question?
Yeah.
Okay. Well, the paperwork, the trust document itself, will say that that the child succeeds to that job. Ideally, the parents should formally resign as a trustee, and then the child becomes the successor trustee and steps into the parents' shoes as far as managing money. So then they manage the estate then until the till the surviving parent passes away, and then once that happens, then the other part of a revocable living trust is it acts as a will substitute, because it's good for managing money while you're alive, but also it serves as a will because it'll say that when I die, and I'm talking in terms of the person who's created the trust, they say when I die, typically it'll say everything goes to my spouse for as long as they live, and income to them and periodic of the rest of me. But when my spouse dies, then the money goes to typically my children. Okay, and for instance, in equal shares. And so that's the will substitute part. That's what a will would say, to say, if I die, this is who gets my property. A trust does the same thing.
So if you just have a will and you write that, when I die, everything goes to my spouse and then equal shares to my kids, how is that not as good as a revocable living trust? Why is a revocable living trust better than a will?
Well, the trust avoids the probate altogether. You will still have a small, you still have to probate, especially if there's real estate involved, because you need to file an estate tax return, and the state has my handout for fees. And in most instances, this year the exemption for estate tax is over $7 million. So most folks don't have $7 million that they're passing to the next generation. But a $7 million estate would result in a very large probate fee. And if there's real estate, then you have to probate it, because associated with that probate fee is a lien. Is a lien on all the real estate that's owned by the person who's died, even if it's owned by their trust. So when they die, then that probate fee has to be paid. And that's in order to get clear title, so that ultimately title can pass to the beneficiaries, or the property can be sold and the money brought into the trust.
So if your parent has, I met with somebody today, I was telling you a little earlier, and his mom just recently passed, but he was in charge helping her for the past few years because she was ill. And in her will, she named the two sons as equal beneficiaries of her estate, yet she never named an executor. So then since last year, he's gone to court to get named as an executor. Is this a common error, or what does everybody need to know? Like, just as simple, if you just have some savings and a house, what you need to know, what are the basics you should have?
Okay, so that's what you just described as a really unusual situation. I don't know a lawyer, unless the mother just simply couldn't decide between her two sons.
Maybe she wrote her own will. I don't know.
She might have written her own will. As long as it's properly witnessed, then it's fine. But I certainly wouldn't recommend that. I think it's kind of a false savings to do that, rather than go to an attorney and get it done properly. As a result, I'm not sure what his trouble is getting appointed as executor. Well, he can't be the executor really, because he's, I haven't seen that situation. he's executing a will, so he does need to be appointed. And so somebody has to have the job of carrying out the term. So that's
Yeah, but you're saying that could have easily been avoided.
Oh, yeah, because every will that I've ever written will say that's one of the first things you say. First of all, you say who gets the property, the personal property, who gets everything else, and then who's going to be the responsible for taking care of this. And you always name one person who's the first person in line, and then you typically name a successor who will do it if this first person can't do it. And
Yes.
those are the kind of the critical elements of a will. And there are a lot of other things that can go into a will, but those are the biggest parts of it.
So Ed, besides a will that's naming the executor and naming who gets the assets, what else should somebody have for their parent?
Okay, so it's part of part of the process is deciding, all right, well, who do I trust for these jobs? And once you make that decision, those are the kind of the big decisions. One, or who is going to take care of me and my property during my life if I can? All right. So that drives the first other document, which is a power of attorney. If you don't have a power of attorney and you become incapacitated, the only way for anyone to kind of deal with your bank accounts, your property, anything, your insurance, or IRAs, 401ks, is to have a conservator, which is a court process, which is completely unnecessary if you have a properly drawn power of attorney. So the power of attorney says, I authorize my son, daughter, great friend, whoever, to carry out, basically to handle my affairs. And it's only good for as long as you're alive. Typically, they'll still be good after you become incapacitated. That is most of the biggest point of this type of power. And you can even name an alternate. So that's the first thing as far as just securing your estate and the things that you own against the problems that arise from being incapacitated.
So power of attorney is only good if you're incapacitated.
No, it's good if it's essential if you're incapacitated. And typically people won't give the power of attorney to their agent until they need to use it. We used to use a form called a springing power of attorney, which would say this power of attorney only becomes effective if I become incapacitated as certified by my attending physician and another doctor. Well, the doctors, they want no part of this. And so not that long ago, I had a client that had a power of attorney was drafted, 10, 12 years ago. She couldn't find a doctor to sign off on her mother, on her mother's incapacity, even though her mother was clearly incapacitated. The doctors, there's so much liability that can attach to it for the doctors.
Oh,
so
in case the mother got better and said like, hey, I was fine.
Well, either I was fine, or if the agent that's appointed makes off with money, and then the mother's estate, the other kids who weren't appointed, can say, oh, look, sis had this power of attorney. She got this doctor to sign off on this, and she took all the money.
Oh.
So the doctors really don't want to be, physicians don't want to be in the middle of that kind of thing. And so it could really be just really hard to manage. So we've really gotten away from springing powers of attorney. So it's a power of attorney which is typically effective immediately. You can always make it contingent on some event. If there's an easier event, like I'm stuck out of the country or something like that, again, you'll have issues with people accepting the power of attorney. How do we know this person? So more often than not, you see.
But how do they know? Like, let's say your parent is in rehab and they have to get their bills paid at home. Can you exercise your power of attorney if they're in rehab for the next 2 months?
Well, this is where that contingency, it becomes a problem. And so that's why we typically avoid that. So what we do is the power of attorney is put in the hands of the the client, and then they can give it to their agent, who, remember, is a person that they trust implicitly with their property.
Mm-hmm, mm-hmm.
They can give it to them when they want to. So that's essentially, when they think they're going to need it, they look, this is my power of attorney, or this is where my power of attorney is.
But let's say I have my mom's power of attorney.
Mhm.
She falls down, and I just spoke to somebody today, not my mom, but somebody that fell down and punctured her lung, a senior, and she's been in rehab for about 3 months. But like, somebody has to go in and pay her bills. So who is paying her house bills and everything? Like, is that what you would use a power of attorney for at that point?
That's exactly what a power of attorney would be for. If this woman who is laid up is incapable of writing a check or calling a bank or going online and making the transaction herself. It really is the kind of incapacity we're talking about. Typically, it's a situation where someone's had a stroke and they can't communicate, or they can't physically do something, or dementia, where they can't properly cogitate and can't properly, cognitively handle the task at hand.
All right. We have a question here from viewer Mike Salvatore.
Hey, Mike.
How is it handled? Is there a way to set up a TOD, meaning a transfer of death, and name a person who'd be responsible for settling debts? So he's asking, is that an executor?
Well, no. The answer I would say is no. What you're talking about is a will, and the only way that the state is set up for what you're talking about is it's either a will or a trust. So those are really the two ways you can do that. So a transfer on death would mean that the money would go to the beneficiary, and then they're responsible for settling the debts. But really, what establishes their legal liability to do that? Be a contract of some kind that you have with them. The system really is not set up for that at all, because the will serves that need precisely. And probate, a lot of people want to avoid probate, and there are good reasons for that. But if it's an uncomplicated estate, probate can go very smoothly. And if there's any, I typically recommend that you have a lawyer help you with it, just because they know the ropes, and can move things along. They know what's expected next. They can kind of make sure that the proper documents get collected, taxes are prepared and paid.
I think people have the perception that there is a cost and a time delay in getting things. And let's say, things have to go through probate, and you want to sell your parents' house, or you don't want to be paying the taxes on it, or, maybe they have a mortgage on it, and you have to now pay the mortgage and taxes waiting for, things get settled. Is that not the case? Isn't it quicker not to have to go through probate, so you have your hands on the assets to be able to pay any of the debt? Is that a misconception?
To a certain extent, it is, yeah. I think that, for instance, if you had a house that needed to be sold, there's no reason why the executor couldn't market and sell that house. As long as they're getting fair market value for it, all the money from it comes into the estate and is used to pay the bills of the estate. Those bills would be bills for the final hospital care. Mm-hmm. They might be, a car loan or even a house loan. With a house, obviously the house is paid off when the house is sold, but that money comes in, and that's the probate estate, and that's really what a lot of people don't realize is the primary purpose from the state's perspective of probate is to make sure creditors get paid. That's job one. And the second part of it is to make sure that the beneficiaries, the spouse and children and the dependents of the person who passed away, they're provided for and taken care of, and they get what the decedent has wants them to have.
So just to get back to what every senior needs to know, they should have a will, they should have a power of attorney. Is there anything else?
They should have a designation of a healthcare representative. The power of attorney, a lot of people might have the and at one point, under a power of attorney, you could name a healthcare representative, but that hasn't been the case for a long time. A designation of healthcare representative is a document that you sign that's signed as witnessed and notarized, and it says that if I can't communicate with my physician and tell my physician what I want, what my decisions are concerning my health care, then this is the person I want to be able to communicate on my behalf and make decisions on my behalf. So it's a really important document. Again, taking into account the possibility that you're incapacitated.
So now, if you don't have that, Ed, because I heard that now in Connecticut, that is not a given that a husband and wife are automatically each other's healthcare proxy or rep. Is that true?
Well, I think, it's really kind of it's technically it's true. I mean, it wouldn't necessarily be that your spouse could speak for you. The hospital really kind of has to, and that's where you would be. They're going to press really hard for some other evidence or some
so what if you're in the hospital and you don't have healthcare proxy and you didn't realize that your spouse wasn't your automatic care proxy married? And what happens, like if you're in a coma? Does the spouse have to file something to get a healthcare proxy, or are they just going to listen to the spouse, or how does it work?
Well, under those circumstances, I think what the spouse would really almost need to do is be to get some kind of a conservatorship to give them authority to handle healthcare decisions and decisions regarding the property of the estate. A conservator is someone who's appointed by a court. It requires a court proceeding. There's attorneys for the person who's applied for it. There's medical testimony. There's someone representing the person who's being served.
How long does that take?
It's a big involved proceeding. I mean, it can be handled on an expedited basis, but typically it takes a while, months sometimes, and it's completely unnecessary in many situations. And it can be avoided to a large extent with a healthcare representative and a power of attorney. And one of the other documents that I prepare for folks is a designation of a conservator, so that if you ever do need one. So for instance, the example I use is a situation where a spouse is taking care of an ill spouse, and there's the one spouse suffering from dementia, and the caretaker spouse just run ragged and says, "Look, honey, you've got to go into a nursing home," and the person says, "I'm not going anywhere." They have the legal right to do that. They have the legal right to refuse to go anywhere, but they're suffering from dementia, and under those circumstances, then the caretaker spouse might apply for an involuntary conservatorship. The drastic element of the conservatorship is that it takes away your legal right to decide where you live, and really it's pretty drastic in that sense. But what it recognizes is you can no longer take care of yourself, and somebody needs to be able to do that.
Do you need a conservatorship or a healthcare proxy to put your spouse into a assisted living facility? If they can't really speak for themselves, if they have dementia?
If they're going voluntarily, then you can do it. It's where you have an involuntary situation that I mean, if they're willing to go along, then it's not a problem. But it becomes a problem. That's when you might need the help support if you don't have these other documents.
All right, so these documents are a will, a power of attorney, healthcare rep, and a designation of conservatorship. And you recommend that everybody has these. Like, at what age should people have these?
Well, I think really, anytime as soon as you acquire any property, you should have a will and a power of attorney. I have a client who come to me and they're very smart. As soon as their son was going off to college, they recognized that if they wanted to find out anything about their son, if he became ill or sick or couldn't communicate, they had no right at all necessarily to get information from the school or to talk to the hospital that he was in. The hospital might talk to them because the parents wouldn't have any legal right to. So that's why they asked me to prepare a healthcare representative and a power of attorney for him.
So anybody that's not married or just anybody over 18 should have this.
I think it's smart, yeah, and it's not a big deal to get to do. Before we get away from the other documents, though, that you need to address incapacity is the living will. And really, I know even Danbury Hospital, for instance, one of the first questions they ask you is, do you have a living will? Because they want to know.
A living will is like the pull the plug or do not pull the plug.
It essentially is instructions to say that if I'm at the the end of a terminal condition and don't keep me alive through so-called heroic measures like CPR, artificial nutrition, hydration, or respirator. Now, it really is you really have to be literally being kept alive with those things. And if it's at the end of a terminal condition, I mean, the question people look, do you really want, you're going to die. All right. This is the mechanism for dying, is stopping breathing or your heart stops. Do you really want to be brought back to life, really only to possibly die the next day? So that's the kind of the scenario. And the other is if you are in a permanent coma and at no time aware of your surroundings. And that's the kind of situation which really more often finds its way into the news media. You have someone who appears to be have cognitive function, but they don't, and they're being taken off of life support. And a living will, actually, that really does allow that to happen. What it is, it's a letter from you to the doctor saying, this is what I want. It's in a lot of ways I describe to my healthcare reps as like a green light for you to do what you need to do.
Well, I know when you did my will and my trust and my everything recently, healthcare practice and POA, I was like, no way. Like, do not pull that plug. I am too young. Keep me in coma machine forever till they figure out how to do it. Yeah, I think that I get the premise, but I think, that for me, I'm going to choose that when I'm older. But now I want them to freeze me with Walt Disney, whatever, keep me going. We do have another question here from Mike. He's asking about, to get a conservatorship, would a person need a letter of incompetency from the individual who's compromised? Like, if you do have dementia, let's say, does a doctor have to say you have dementia so you can get a conservatorship for that person?
Yes, so they're voluntary and involuntary, and you need some kind of medical evidence to present to the judge, because the judge needs to have determined that the person is incapacitated and needs a conservator. Yeah. That
makes a lot of sense. Hope that answered your question, Mike. Well, I know I kept you kind of over time today, Ed, and you are so busy these days with all your wills and your trusts and your real estate closings. So I really appreciate the time that you gave us. And I know that you are working 20 hours a day.
My pleasure.
If you would like to get in touch with Ed, I will give you the number again so you can get in touch with Ed. You work out of Danbury, but you service Fairfield and New Haven counties, right? Basically the whole state of Connecticut.
But mostly Fairfield County and New Haven County, yeah.
All right, so Attorney Ed Kelleher is 203-518-5602.
And Litchfield County, up in especially New Milford, the New Milford area.
Won't you help anybody in Connecticut?
Well, I don't want to have to drive too far.
Oh, it's not about driving. What if they drive to you?
Oh, they can welcome to come to me, yeah.
All right, that makes sense. Thank you so much. And as always, you're a wealth of information. And I love that you love to share and give of yourself. And I really appreciate that, as I know the people watching enjoy that too. So to get in touch with Ed Kelleher, 203-518-5602. Ed, as always, it's a pleasure. And, I trusted you with my will on my estate, and it was a little complicated, but thank you so much for doing it. And still need to send me a bill. That's another story. So we will talk after the show. But thank you so much, and my best to you.
Thanks, Deirdre. Have a great week.
Thanks so much. Bye-bye now. That is attorney Ed Kelleher. He is a great guy. He is a straight shooter. You're going to get the real answers from Ed. He doesn't beat around the bush. He just tells you what you need. He won't give you what you don't need. He won't sell you a bill of goods, but he's going to tell you exactly what you need. He's very conservative. So he will definitely help you plan your future, help you save your money, help you from going through probate. Now that I'm working with so many seniors, I see the pitfalls people make. I have a gentleman whose wife is a senior, incapacitated, and no kids, and he doesn't have a power of attorney or a healthcare proxy for himself. So if anything were to happen to him, what would happen to his wife? So these are all questions that Ed would address and help you with, because it's not just about one person, it's about both of you. You never know what's going to happen. There are just so many different scenarios that can play out, and you need to be prepared for them. A little funny story that I had a gentleman, I was making a bid on his house in Bridgeport, and he had no kids, no wife, and he had no will, and he was 75 years old, and he had a bunch of property. And I said to him, like, do you have, after listening to Ed, I'm like, do you have a healthcare proxy and a will and, everything set up already for you since you're alone? And he was going into the hospital. And he said, I don't care what happens when I die. That's, for everybody to figure out. I said, you own houses, you own property. He's like, I don't care who gets my money after. I said, well, I'm pretty sure the state's going to get it if you don't designate a friend or somebody. Lo and behold, don't hear from him. And he's in the hospital. He had a stroke. And now he's looking to sell things. And now he's looking to do a healthcare proxy and a will and all. Why? Because, it's one thing if you just die. You don't really care what happens to you. But the chances are we don't just die. Like, we could be in a position that we need care. And especially if you're the last survivor of a partnership, or you're unmarried or not married. And what happens when you need care? Who's taking care of all your assets? Who's going to do that? So people need to think about that. This is a real thing with people living longer. So lots of food for thought. So thank you again, Ed. Much appreciated as always. And say hi to your lovely wife, one of my favorite people. And until next time, I'm Deirdre Verva. Stay safe.